Giles Dixon from ContractStore is going to take us through filling in and signing legal contracts. Giles, at the top of the contract we have a space for the date and the parties. How do we fill those in?
Well, the date, although it's the first thing that appears on most agreements, is actually the last thing that you fill in, because the date is usually the date upon which the contract has been signed by both parties.
So the date is in fact the last thing that is filled in after the contract has been signed?
Correct. So far as the parties are concerned, if the parties or one of them is an individual, then you insert the full names of that individual and their residential address. In the case of a limited company, you would put in the name of the company, probably the company number, which is the registered number at Companies House with an English company, and the registered office address, which is the official address of the company, which again is available on the website at Companies House. That's the address to which all formal documents are sent.
So for an individual, it's their home address, and for a company, it's the registered address and also the company number.
Yes, that's right. When it comes to signing the contract, obviously you've read it all through before you sign, and at the end there is space for signature. If a party is an individual, then that individual will sign with his normal signature. If the party is a limited company, then a director of the company should sign. And I say a director because under English law, a director has what the lawyers call ostensible authority to sign, which means the company is bound. A junior manager might possibly not have the same authority. So generally speaking, get a director to sign if it's a company.
So when a company is signing the document, it should be a director because they have authority to sign the document.
That's right.
Does a signature have to be witnessed?
No, they don't have to be witnessed. Not under English law. Some countries require a witness. But it's quite often that witnesses are required because it's evidence that the person who is purported to have signed has actually signed the agreement. There is one aspect of documents in England where a witness is required, and that is if the agreement is signed as a deed. A deed is quite often an agreement which is either a gift without any consideration or a long-term contract.
And what do we do if there are last-minute changes when signing the contract, or even after signing the contract we want to change something?
If you're going through the contract before signature and you find some small error, if you don't have time to get it retyped, then make the change in manuscript, and then both parties should initial the change in the margin. And that's evidence that the change was agreed by both sides. If a substantial change is required, then you're much better off getting the agreement retyped with that change in it and then sign the agreement. Or alternatively, if there's some rush, you could have an amending agreement. So you sign the contract and then later on you have a separate agreement which amends it. But normally you'd make the changes before you sign the first contract. It saves the paperwork.
Thank you very much.
Thank you.